Hello, everyone. Welcome. I'm Jay Lazega. Welcome to this session of Lazega Johanson's Morning Break. We are happy you're here, excited you're here. We love doing this, and we're happy to have another program for you today. We hope that you are enjoying these. We love hearing your positive comments and feedback. We hope that you are also watching these and sharing these with your board on our website, ljlaw.com, the resources section, and also using some of the forms and samples that we're given. We think that in a time like this, it's really important to give you guys some some takeaways that you can use for your communities, tweak and use as you want. Of course, they're not specific legal advice to any community, but we've got some great samples for you. We've got amenity signs, we've got waivers, release agreements, we've got sample letters you could use to communicate to your community, because we know that this is certainly an emotional time in communities, and hard decisions for boards, and how, when, whether you open your amenities. And Governor Kemp is not always making it easier for us to make those decisions. So we're going to talk about that today. Today's session is, I like to actually think of it as, are we there yet? So much is happening, so much is changing, so much is moving. Governor Kemp issued another order, which on its face seems to have relaxed a couple of things and maybe made it easier to open and operate amenities. But on the other hand, he still defers to the Georgia Department of Health, who still has the same guidelines in place from May and hasn't at least yet changed those. So maybe we can't change how we operate yet. But we have today with us Jonathan Benader and
Hi.
hello, Jonathan, and Danielle Kaplan. Hello, Danielle. Welcome to talk about where we are today. So for you guys, you know that we don't answer questions in this session, but if you have questions, there is a questions tab on your menu bar. Please send them in, and we'll even keep the session open a little bit after we finish, so you can send questions, and we'll reach out to you individually to get back with you. We love hearing from you. Thank you for joining us. Jonathan's going to start. Jonathan, have at it.
All right, thanks, Jay. So welcome, everybody. I appreciate you taking a little bit of time out of your day to listen to me talk about some of the recent changes to Governor Kemp's executive order. It seems like as soon as we get a handle on what the previous executive order said, he goes and changes it. He is definitely loosening up some of the restrictions, and I want to go over how that impacts your community association. So there are two main changes that I think you should know about. The first is that the requirement that people who are over the age of 65 have to shelter in place has been removed. So that's no longer on the table. It's only people who are medically fragile that are supposed to continue to shelter in place. And that includes, among other things, people that are obese, people that may have diabetes or heart conditions, people that live in nursing homes. So that's something that you should know and keep in the back of your mind. The other big change was that Governor Kemp removed the requirement that nonprofit corporations have to enforce social distancing. So what does that really mean? It means that it's no longer a legal mandate to do so. So if you don't have a pool monitor, you're not going to be subject to a misdemeanor, which could be up to 12 months in prison or a $1,000 fine. But as Jay mentioned, the Georgia Department of Public Health and the CDC still recommend that you enforce social distancing. So while it's no longer a legal mandate subject to criminal penalties, it's still a recommendation by the relevant health agencies. And so there could be civil liability if you don't enforce social distancing. And so our recommendation to clients is that you should keep your rules the same way that they've been in place and continue to try to enforce social distancing. But just know that there's not as much risk from a criminal standpoint if you don't have a pool monitor in place. And all the other requirements about sanitizing, the premises and posting signs, etc. Those are all still in place. None of that has changed. And we're hoping that the Georgia Department of Public Health, at the very least, is going to change their guidance to match Governor Kemp's executive orders, just so that there's consistency. And we're not left wondering, well, if we do the bare minimum and comply with Governor Kemp's executive order, you know, are we still subject to liability because the Georgia Department of Public Health says that we need to do X, Y, and Z. So we've been getting a lot of follow-up questions about, you know, what does this mean for us practically? Can we allow guests? Can we have swim meets? And I'm going to speak briefly about swim meets, and I'm going to let Danielle, my colleague, talk some more about adult supervision of children and just, you know, updated guest policy. When it comes to swim meets, what you should know is that there's still a prohibition on gatherings. And gatherings is defined in such a way in Governor Kemp's executive order that if you're going to have more than 50 people at the pool, everyone has to be able to sit or stand 6 feet apart from each other. Not just people from different households, but everybody. And that cap used to be at 10 people, and then it was increased to 25 people, and then just recently was increased to 50 people, pursuant to the most recent executive order, which is in effect until the end of this month. So if you're going to have swim meets, you got to know that you still can't have more than 50 people at the pool if you're not going to be able to keep an appropriate distance. And then another issue is that the CDC says that if you are going to have events, you need to be able to stagger drop-offs and pickups. You should limit non-essential visitors and groups. And then the Georgia Department of Public Health says directly that you're not supposed to have swim meets right now. So if you do have a swim meet, at the very least, you're going to be violating the guidance put forth by the Georgia Department of Public Health. Now, I have had some conversations with communities that want to do swim meets, and what I've heard from Atlanta Swim is that they're not actually going to have what they call swim meet. They're going to have timed practices. So they'll just have one team at the pool, and then they'll time those races and compare that against other teams doing timed practices at a different pool. So you want to evaluate those things on a case-by-case basis. Just know that, as a quick recap, gatherings are still prohibited, which is more than 50 people. That the CDC says that you should limit non-essential visitors and groups, and the Georgia Department of Public Health says that you shouldn't have swim meets. Whether or not it is a swim meet or it's something else, like a timed practice, you got to look at that on a case-by-case basis. So I hope this information has been helpful. I'm going to let Danielle talk a little bit about supervision for children at pools and then updated guest policies. All right, thanks.
Thanks everyone for being with us again. I just want to introduce myself for a second. My name is Danielle Kaplan and I'm an associate attorney at the firm. Like Jonathan said, I'm just going to talk a little bit about some things that we've been receiving questions about from associations. First, in terms of guests. So we've been receiving questions about whether we should prohibit guests from using the amenities. And our typical advice is that yes, it's most beneficial for the association to prohibit guests from using the amenities because it increases the potential pool of claimants, pun intended. So the more people that we're allowing at the pool and at the other amenities, the more potential claimants that we have in the event that there's an issue. And as you know, we've been recommending that all associations have all of the owner and occupant sign waivers before using the amenities. And we can try to police that with, you know, our records, maybe by turning off fobs to the pool or to the other amenities if we have fob access. And it's difficult to monitor who has signed the waiver when we're allowing guests. We just don't know who's at the pool and we don't know who signed the waiver. So that potentially opens up the association to additional liability. Another potential area of concern is that many declarations or bylaws include some waiver language, disclaimer language, saying that the association is not responsible for the health or safety of owners and occupants. And that language will most likely not apply to guests. So it could just lead to more potential liability when we're having guests at the pool. And so for that reason, we're recommending that associations prohibit guests at the amenities, but it's of course ultimately your decision. It just creates another risk factor for associations when we're having more people at the pool, for which, you know, they might not sign waivers, and that could lead to more liability for us. Another issue that we've been getting questions about is in terms of age regulations at the pool. Our typical advice is that it could potentially lead to an FHA claim if we are saying that, if we have a rule in place at the amenities saying that children under 18 need to be supervised. And the reason that that could lead to an FHA claim is because it's not reasonably related to the health or safety of a child. Usually a rule like that is in place in order to prevent the typical nuisance that groups of teenagers might cause when they're unsupervised. But it's not necessarily related to their health or safety, because children as young as even 13 or 14 can appreciate the risk of being at a pool, namely slips and falls, or just, you know, inherent risk with the pool, you know, drowning obviously being the main one. And that's because children as young as even 15 can be certified to be a lifeguard. So the idea is that children, younger children, you know, 13 or 14, should be able to be unsupervised at the pool in terms of being responsible for their own health or safety. And so our thinking is now that there's an additional risk at these amenities based on the coronavirus. And so that children might not be able to appreciate this risk at an older age. So it might be possible for associations to try to raise that age supervision limit from, you know, a 13, 14 to maybe a 16, 17, because there's this additional risk that children might not be able to appreciate. Most children, you know, have a lot of experience dealing with the inherent risks of a pool, but this is just a new risk factor. And a lot of children probably won't be able to appreciate the risk of coronavirus, and to be able to adequately try to prevent that risk to them in terms of social distancing, hand washing, or other measures. So we're thinking that, you know, we might have some more flexibility here, but it could still be an area for concern in terms of an FHA claim for discrimination. This is such a new area. I'm sure that this has been mentioned to you before, but this is such a unique time. There isn't a lot of legal precedent on this, so we're just trying to think about everything that we can to deal with this unique circumstance. But it's ultimately, of course, a decision for you. We can just tell you what things to do to try to limit the risk as much as possible. And I think that's everything that I wanted to discuss this morning. And thank you again for being with us.
Great, thank you guys. Great information. And I think we all know, real world, good luck getting 15-year-old kids to socially distance. Definitely a different situation and a different level of what they don't understand from just how to swim and use a pool. So we do think maybe there's some room to be a little more aggressive on age regulations potentially. So one other thing I want to talk about with Governor Kemp's, real quickly, newest executive order, and honestly, I think this was a mistake, but one of the new changes in this executive order is that in earlier orders, he specifically covered and said, it's okay, and almost that we suggest that corporate entities should use Zoom or other video platforms for meetings and not meet in person. And that's not in the most current executive order. And it's probably because in the earlier order, it was tucked in a section that didn't make sense, and they've essentially deleted that section. He probably just didn't realize what he did and eliminated the validation for Zoom meetings, for board meetings, membership meetings, violation hearings, and other things. So that's a little confusing, but one of the good things is, and it's important to start talking about this now as we approach annual meetings, is even before he said that in his first executive order, we've said for years that we believe the nonprofit corporation code allows almost every community association the ability to do that anyway, to conduct voting by mail-in ballots, to do meetings by video as long as people can hear each other, not even necessarily see each other. So we frankly say continue to do that. And we know we're approaching annual meeting time. We're not that far off where we got to start planning. And what I believe, what we advise is you should not be doing traditional annual meetings this year. Come November, December, we should not be filling rooms with 100 members and conducting normal annual meetings. That what makes more sense, and frankly, we've said this even before this year, is if our documents allow us to do it, stop doing our elections at annual meetings. Do the entire thing online or by ballot. So much simpler. Take that piece out of the annual meeting. Annual meeting then essentially is just presentation of financial reports and information, maybe Q&A, and that can easily be done in a platform like this, GoToMeeting or Zoom. So as you start over the next few weeks or months planning, discussing your annual meetings, we think you should do this. Call or email us if you want to talk about how that works. We're happy to help you. But I think in this year, absolutely, there should not be a year of annual meeting gatherings. Just doesn't make any sense at all. Okay, thank you for joining us again. Visit our website, ljlaw.com. The resources section has great stuff, forms, samples, other videos. You can find information on us on Facebook and LinkedIn. We've got more information, so visit us there. If you have questions, you have topic ideas, you'd like us to cover things in either our e-blasts or our blog or these videos, shoot us a note, shoot us emails, call us. We love hearing from you, text us. And if you have some additional questions, we will keep this open for a couple more minutes so that you can type those. But we're glad you joined us and we miss you guys. Stay safe, be well. Thank you.